Termination by employer just cause Heavylift Manila Incorporated versus the Court of Appeals. GR number 154,410, October 20th, 2005. Facts: Heavylift Manila Incorporated, through a letter signed by Evangelio, administrator and finance manager, informed respondent Galley Insurance and Provisions Assistant of her low performance rating and negative feedback from team members because of her attitude. The letter also informed her of being relieved of her other functions. Except for the development of the new access program, Galley was terminated for loss of confidence. So she filed for illegal dismissal. Heavylift averred that the attitude problem of Galley led to decline in company's efficiency and productivity, therefore analogous to loss of trust and confidence. With this, they could no longer make her in charge of the confidential crew information system, which accounts for the personnel, management, and professional records of all the employees of and seamen connected with the company. Labor arbiter found Galley illegally terminated for failure to state what company regulation she violated and failure to give proper notice. Petitioner, however, averred that they sent Galley a letter of notice regarding her low performance and attitude problem in February, after which they sent a letter of termination in August. They even waited 6 months for Galley's counseling before dismissing her. Galley countered this by saying that the letter given did not comply with the twin requirement, because it neither informed her of her infraction of any company rule, which warrants disciplinary action. Issue: whether or not attitude problem was a just cause for termination. Ruling: yes. An employee who cannot get along with his co-employees is detrimental to the company, for he can upset and strain the working environment. Without the necessary teamwork and synergy, the organization cannot function well. Thus, management has the prerogative to take the necessary action to correct the situation and protect its organization. When personal differences between employees and management affect the work environment, the peace of the company is affected. Thus, an employee's attitude problem is a valid ground for his termination. It is a situation analogous to loss of trust and confidence that must be duly proved by the employer. However, petitioners have not shown sufficiently clear and convincing evidence to justify the respondent employee's termination for her attitude problem. The mere mention of negative feedback from her team members regarding her low performance rating and her work attitude is not proof of her attitude problem. Likewise, her failure to refute petitioner's allegations of her negative attitude does not amount to admission. However, in this case, there is no clear and convincing evidence to justify Galley's termination. The mere mention of negative feedback from her team members and the letter dated February 23, 1999, are not proof of her attitude problem. Likewise, her failure to refute petitioner's allegations of her negative attitude does not amount to admission. Technical rules of procedure are not binding in labor cases. Besides, the burden of proof is not on the employee but on the employer, who must affirmatively show adequate evidence that the dismissal was for justifiable cause. The notices do not meet the twin requirement, because it does not inform her of specific acts complained of and the penalty. Similarly, compliance with the twin requirement of notice and hearing must also be proven by the employer. The law requires the employer to give the worker to be dismissed to written notices before terminating his employment, namely: 1. A notice which apprises the employee of the particular acts or omissions for which his dismissal is sought, and 2. The subsequent notice which informs the employee of the employer's decision to dismiss him. Additionally, the letter never gave respondent Galley an opportunity to explain herself, hence denying her due process. Hence, Galley was illegally dismissed.